Welcome to this discussion of the proposed Pandemic Heroes Compensation Act. This is your host, Jason Shoup, founder and managing member of the Centers for Better Insurance. The Pandemic Heroes Compensation Act, or H.R. 6909, was introduced in the U.S. House of Representatives on May 15, 2020. The program is intended to deliver no-fault compensation to essential workers and their family members who have contracted COVID-19. The structure of the program is based on the September 11th Victims' Compensation Fund. The program would reside in the Department of Justice. The U.S. Attorney General would appoint a special master to administer the program. The special master would establish the claims procedures, compensation methodologies, and claim forms. In addition, the special master would set up an office to assist claimants in submitting their claims. The cost of administering the program, but not the compensation awards, would be part of the DOJ's budget. Let's dig deeper into the program to understand who would be eligible for compensation. An eligible claimant is an essential worker who worked outside of the home during the period of an emergency declaration, or a family member living with such a worker. If that worker or family member has exhibited symptoms of COVID-19 confirmed through a laboratory test, a healthcare provider diagnosis, or the absence of an alternative diagnosis. The claimant or surviving family member must submit a claim form with the program within 5 years after the end of any emergency order or declaration relating to COVID-19. The claim form requires information regarding the harm suffered as a result of COVID-19, status of the claimant as an essential worker, the economic and non-economic losses as a result of COVID-19, and collateral sources of compensation. The special master makes a compensation award without considering the negligence or fault of the worker or any other person. This award consists of economic losses, such as medical expenses and lost wages in accordance with applicable law, and non-economic losses, such as pain and suffering, as limited under the rules established by the special master. The compensation award would be reduced by any collateral sources of compensation the claimant may have received or is entitled to receive. An award of punitive damages is not permitted. While the special master makes the award, U.S. Treasury is responsible to pay the award through the COVID-19 Compensation Fund. The collateral source rule is a long-standing legal concept, generally prohibiting a person from receiving compensation twice for the same element of loss. Workers' compensation benefits would be considered a collateral source under the program, thereby reducing the amounts awarded. That sounds fair until we understand why essential workers may have received workers' compensation benefits. As a practical and legal matter, viral infections such as COVID-19 are rarely covered under a state workers' compensation system because, 1, benefits are not available for diseases to which the general public is exposed, and 2, the worker must establish that the disease was contracted while on the job. With the intent of rushing benefits to essential workers, more than a dozen states have made the decision, at great cost, to open their workers' compensation systems to COVID-19 claims by some or all essential workers. For example, California's broad expansion of benefits is expected to cost some $1.2 billion. The proposed program penalizes states that extend workers' compensation benefits to essential workers. As currently structured, H.R. 6909 would fully fund medical costs and lost wages of essential workers in states where workers' compensation benefits remain unavailable. In contrast, employers and insurers in any state that opened up its workers' compensation to first responders, healthcare workers, or other essential workers would bear those costs. That doesn't seem quite right. Curiously, the proposal does not carry over from the Victims' Compensation Fund any requirement for claimants to waive their right to sue. As a result, the proposal would allow a claimant to recover first under the program, subject to the program's limitations on non-economic damages such as pain and suffering. Claimants could then try their luck with a jury to see if the non-economic damages awarded in a court would be higher. Of course, any amounts recovered in a lawsuit duplicating the amounts previously paid by the program would go back to the federal government, less the attorney's contingency fee. This approach seems to complicate rather than streamline the efficient delivery of compensation to essential workers and their families. A program based on the 9/11 Victims' Compensation Fund can certainly be structured to fairly and efficiently support our nation's essential workers. H.R. 6909 is a good first step in a public policy debate requiring a wide diversity of perspectives and experiences. You can learn more about the Pandemic Heroes Compensation Act at betterins.org. On behalf of the Centers for Better Insurance, thank you for spending this time with us today.